Let's take that opportunity. I know that people will be joining us as the time progresses. We are delighted that those of you who are able to come have showed up so far. This is the first in a series of Loyola events where faculty are gathering together to give some of their expertise on the particular ways in which the law has or has not responded during the pandemic. We've got a series running all through June on the impact of the law on COVID-19 and on the impact of COVID-19 on the law. We're starting out today. I am joined, my name is Dean Justin Levitt. I'm joined by my exceptional colleagues, Aaron Caplan and Kimberly West-Faulcon, both extremely noted professors of constitutional law at Loyola. Some of you, I am hoping in the audience, may have actually had them for class. And if so, I hope this is a little welcome reminder. We're going to focus today on what the Constitution tells us about response to COVID-19, because these are extraordinary times, and it turns out some of that was anticipated by constitutional doctrine. And in other ways, some of what's going on now is testing what's going on in constitutional doctrine. I do want to invite every panelist, every participant, to use the chat function on Zoom. If you have questions, we want this to be as interactive as possible. My rambling now is going to be about as long as I talk for the entire next 45 minutes. We want to keep our responses fairly short. We want to respond to you. So if you do have questions, please use the chat function in Zoom to ask us your questions. I'll be tallying and we'll respond as best we can. With that, I'd love to launch in. So COVID-19 is obviously all around the news, and the various measures that states and the federal government have been taking are all over the news these days. Some of that is controlled by or governed by or bounded by the Constitution. So Aaron, let me pitch to you for the first little bit. We've seen a lot of protest against some of the measures being taken in the states for ostensible purposes of public health and safety in order to get past the initial wave of this virus. And some people have been claiming that the lockdowns or the shutdowns of the restrictive measures violate the Constitution. So help us sort out fact from hyperbole. What does the Constitution actually have to say about some of the lockdowns in place now?
Sure. Well, I want to emphasize two words that were in your question. One word was states, and the other word was the Constitution. So as folks will remember, constitutional questions might give you very different answers depending on whether we're talking about a state government doing something or the federal government doing something, and if there's a limit on what either one of them can do, is that coming from the U.S. Constitution or from a state constitution? So most of, actually all of the stay-at-home, closed businesses, lockdown orders are coming from state and local governments right now. And so we'll focus on that. Generally speaking, state and local governments have authority to do pretty much anything unless the Constitution of the state, excuse me, or of the federal government specifically tells them that they can't. So our starting point for state and local government is they can do anything that they think is a good idea, unless there's something specific telling them that they can't. So we often refer to this as police power, the power of the state government to do things that are good for the health and safety and welfare of the citizens. So
we're used to thinking about the Constitution, though, as protecting some freedoms and freedoms
Sure.
that we as individuals have. So what about states requiring us to stay in our homes or states requiring us to not gather at work? Is that legal? Is that kosher?
Yeah, so that blends into the second part of the answer. I said states can do whatever they think is good for health and safety, unless there's something in the state constitution or the federal constitution that tells them they can't. So, for example, some of the things that you find in state constitutions have to do with separation of powers. Could the legislature tell people to stay at home? That would be one thing. Can the governor or the state Department of Public Health tell people they have to stay home? That could be something else. So in Wisconsin, for example, the state director of public health issued some stay-at-home orders. The state Supreme Court said, hey, under our state constitution, that's something for the legislature to do. the health department didn't go through the steps that are required by the state constitution and the state statutes on the subject. So you end up having to look specifically at what the state has set up. Now,
let me ask Kim a follow-up to that question. If a state has certain rules about what the legislature can do or about what the governor can do, and let's say the governor just kind of does something that's not in the state constitution, is that a federal constitutional issue? I mean, we've seen some claims that the governors of some of these states are acting beyond what the state constitution lets them do. Kim, is that a thing that the federal constitution talks to? Is anybody going to come into federal court to sue over that?
Justin, I'm going to be a really bad example for potential law students we have listening, which is I'm not going to answer your question yet. I'm going to say what I want to say. So those who are subjected to our Socratic method, do what I say, not what I do, because I'm going to answer the first question and then I'll give you a chance, Justin, to ask you that as well. But I do want to take a swing at the big picture question about COVID and the Constitution. You've got Americans standing in front of various government buildings, waving flags with signs that say the U.S. Constitution protects my right to go to the gym, my right to go to work. And so I want to be very definitive and clear that big picture, one of the things that you take away from law school is that we do not have a U.S. Constitution that protects positive rights. So I want to go back to just that very first big picture point. We could adopt and ratify a new constitution that had more similarities to constitutions in other countries that actually confer positive rights to do X, Y, or Z. And that would be a different kind of protection. We do not have a constitution that protects a fundamental right to shelter. We do not have a federal constitution that protects a fundamental right to education. We don't have a constitution that has been interpreted in a way that even protects a fundamental right not to be choked to death by a public official, a police officer. So the notion that the federal constitution confers an affirmative protected right to do the types of things that people are putting on signs is just not doctrinally accurate. And so really big picture, the other way I start my constitutional law class, and if I'm fortunate enough that anyone who's on this webinar has actually been a part of this will be repetitive, but it's with some quick and dirty political theory, which is to take us back to Thomas Hobbes, who says without government, we live in a state of nature where we all exert our self-interest. We have unlimited liberty, freedom, America, 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 July 4th, wrap yourself in the flag. We can do whatever we want with all this freedom. But in this context, why is life nasty, brutish, and short? We can be assaulted by anyone because there's no consequence. We don't have roads, we don't have schools, we don't have all the things that our collective willingness to be governed confers to us. So as a basic proposition, it is doctrinally inaccurate and inconsistent with what those who have the privilege of attending law school and taking constitutional law know, is that you do not have a right to any absolute rights at all under the Constitution, that our U.S. Constitution confers liberties, some liberties protected, which again, as my students will remember, I have high hurdles. There's some liberties the government can regulate, but must get over a very high hurdle in order to be justified and legally able to regulate you. But there are many things that the government can regulate in your life that the government is not subject to the high hurdle, maybe subject only to the intermediate level of a hurdle, or the lower level hurdle that I say is so low it's more like a speed bump. And so big picture, when the government has an exceedingly good reason, a compelling government interest, and our national security, our health and safety, our life, even if we were talking about the federal government, state government, any government is really doing what we have government to do, which is to protect us. And why we need government is that there are going to be circumstances in life where if you act in your own self-interest, if we all act in our own self-interest, we all possibly die, but we kill others. And so the big picture point that our fellow Americans are missing is that their liberty starts, it's that notion of your right to reach out your arm stops at my nose. The same with your right to go to the gym, the same with your right to go and do whatever you'd like, drink in a bar. And so it is absolutely oversimplified and doctrinally inaccurate, the vast majority of the things that people are asserting in this context. So that's my long answer to the question you didn't ask me. But I'm happy to answer the other question too.
Well, let me pick up a thread just running from that, and there are a few questions already coming up in the chats, by the way. That's great. People, please feel free to type the questions that you have. Some people have talked about a few specific liberties in the Constitution. And before I get to some of those that have engaged some of the most controversy, Kim, you were just talking about the government's ability to take steps to help protect us. What does the Constitution have to say about, for example, shutting down businesses, right? Preventing people from going to work in order to make a living for themselves or their families in order to protect the general public? What's the Constitution have to say about that? Because that's been part of the protest out there in the streets, right?
Right. So excellent question. And I will reiterate what Professor Caplan has said with respect to the difference and the clarity we want to make sure we have between the federal Constitution and the state Constitution. Our federal Constitution is the Constitution that I'm emphasizing is a Constitution of what we kind of say are negative rights, but essentially what I focus on with my students is it's a Constitution that focuses on limiting government power. So our liberty comes from not being subjected to a tyrannical government. Our framers were most focused in creating the original Constitution, meaning the part with the articles, before we even got to the Bill of Rights, was creating something that was not a monarchy, creating a way that government could give us the good of government without giving the bad of oppressing and tyrannizing us. So that's why we don't, and our framers didn't deem it necessary to list out all our rights. It is ultimately intended to be an exceedingly rights protective document because we're supposed to have all the liberties that we had before we agreed to give the government a limited amount of power. So our liberties are only supposed to be narrowed to the extent that it is explicitly delineated what the federal government can do to us, for us. And as Professor Caplan also distinguished, the federal Constitution was not focused, the original portion of it, on limiting the power of state governments. The states were pre-existing. The states, the colonies at that point, however you want to think about them, were deemed to be the entities that could protect us from a global pandemic. And they certainly understood that. So their general police power to do things of that sort. But your direct question about a fundamental right to practice one's trade or profession is quite literally what those of us who have taught you constitutional law for some time, those who might come, is what we studied in the Locker era and told you that the Supreme Court had a very brief period of time where it asserted it protected such a right, really didn't do it in a way that was very principled, in fact did it in a way that favored big businesses to the little guy. So we've never had, under federal constitutional law, any cogent and coherent and sincere protection of the little guy, an average person's right to go and do their job. And in fact, big picture, when you think about it, quite obviously, and maybe sadly, you don't have a fundamental right to a job. You don't have a fundamental right to a roof over your head, food, nor education. So you definitively don't. And in fact, we test you in your constitutional law exam on the fact that that is counter precedent now. So while it is exceedingly helpful as a political matter to feed the notion that you're somehow being deprived of something, we know we also live in a society where if your employer, absent unions, decides that they want to let you go and fire you, we don't have either in the federal Constitution or in the state Constitution any protection. You can't go to court and sue for most Americans if you lose your job. So that is, if there is a low level toleration of that outside the context of the need to protect human life, when you think about it doctrinally, there's absolutely no prohibition against the government regulating how you do your job or regulating businesses in order to save lives.
So let's take
if I could follow up on this question of, can the government tell me I have to close my business?
Please.
Even if it's not during a public health crisis, the government does that all the time. Let's say I wanted to have a business where I sell people crystal meth and heroin. Let's say I wanted to have a business where I sell tobacco to 10-year-olds. What if my business was to operate a house of prostitution? There are laws saying certain things you're not allowed to do, and calling it, well, that's my business, this is my profession. It doesn't protect you from the government's use of its authority to enact laws that are good for the public health. Now, an interesting question that often comes up in any constitutional scenario is, who decides? Okay, who decides whether I get to sell crystal meth? Who decides whether I can run a house of prostitution? Typically, we have our lawmaking process for that. One thing that's different about the way our system is set up in public health emergencies is that decisions that ordinarily get made by legislatures are often delegated to public health authorities. Now, this isn't really in the Constitution anywhere. There are a lot of states that have passed laws about this. Most of these, in their earliest form, started in the late 1800s. There were a lot of them in the early 1900s, where a state legislature might pass a law saying, we're going to create a public health department. And if there is an epidemic or a pandemic, we hereby authorize the public health department to make orders that are good for health. So the legislature is not completely silent in those cases. The legislature has said, yes, we want this decision-making power to be placed with somebody who's knowledgeable and can act faster than the legislature can. To some folks, that might really sound dictatorial. And in the Wisconsin opinion, there's some concurrences that says this, who died and made the commissioner of public health king over everything that happens in Wisconsin? Well, according to the dissenters, it was the legislature of Wisconsin that gave that person that power to act quickly. And if you don't like it, that can be changed. It wouldn't even require change in the Constitution. It would just require change in the statutes.
One of the things that public health authorities have been doing in quite a few places is not only deciding which businesses can stay open or have to be shut and under what conditions, but they've done something that feels to many people a little closer to home. They've asked us all, or in some cases required us all, to wear masks or to wear other facial coverings. What's the Constitution say, if anything, about that? Can state public health authorities, Aaron, require us to wear masks whenever we walk around outside or when we walk around near each other?
So the way you would think this through as a constitutional lawyer is you say, do we have something specific in the Constitution about this particular kind of right? As Professor West-Faulcon said, most of the things that you might want to do on a day-to-day basis are not listed as special rights in the Constitution. So wearing the kind of clothing that you want to wear, putting on a mask, not putting on a mask, it's hard to pin that down to something specific in the Constitution, like religion or speech or cruel and unusual punishment or these other enumerated rights. So in fact, I think it's kind of interesting. The most common laws that have been on the books about masks have tended to be laws making it illegal to wear masks in public. Part of this is to cut down on crime and unidentified people being able to go into banks and rob them, or political and racial violence. The Ku Klux Klan wore masks and they used that to terrorize people. So in some states you have laws saying it's illegal to wear masks. Well, if you can make it illegal, there's a pretty good chance you can also make it mandatory, and it's a choice for the decision makers.
I'd love to weigh in on the mask question. That's what's great about doing something like this. I will, like Professor Caplan, be doing it off the top of my head, but I'd agree with the way he starts analyzing the question, which is We have listed, as Professor Caplan said, enumerated rights. You find them very few in the original Constitution, but in the Bill of Rights, the First through Eighth Amendments. We do have the textual support in the Ninth Amendment of the fact that what I was referring to earlier, that there was a reminder that some of the framers wanted put in the Constitution. If we're going to start listing rights, their great concern was that the listing of rights would lead someone down the line to argue that the only rights we have are those that are listed. And so I would credit the person who's asking the question with taking us to task, or at least engaging with the point. If I have liberties that are unlimited, and the federal government and the state government, we'll come back to the state government with the general police power, but there certainly can be the notion that if I have all sorts of unlimited liberties and the government is limited in its power, then explain to me why I wouldn't have the right, the unenumerated right, to choose whether or not to wear a mask. And so I think that takes those of you who've had us before for constitutional law and heard the phrase substantive due process or unenumerated fundamental rights, that would be the place to start. And again, I think that's what Professor Caplan is ultimately alluding to. And I want to take that, again, a little bit farther down the route to say that, so in law school, and before you can get out of our classes, you have to go through the process of learning how one would go about arguing that what is currently a non-fundamental liberty interest would reach the level of being a fundamental right, such that it would be subject to that high hurdle of scrutiny. The other thing I'll again remind, and for those who don't want to be taken straight back to law school, I apologize, but the idea would be that there's just the big picture point that you have liberty, interest, and rights that are not absolute, nor does the government have absolute power. So I would say that you could file a lawsuit. If you got the right, judge, you could file the lawsuit. You could try to give it a go and say, well, do I have a fundamental right to decide for myself whether I want to wear a mask? And there would be a complexity to the answer to that question that would be impacted by various already existing precedent. What came to mind in thinking about how to answer this question is to think about the fact that in other countries like France, people have been prohibited from wearing face coverings based on their religion. Now, the purpose behind that prohibition is not national security. It is not to keep people safe. So if Governor Gavin Newsom was having us to cover our faces for an illegitimate purpose, a racist purpose, an anti-religious purpose, a purpose of just having us conform for the sake of conforming, I think we'd have a very strong case, and I'd be ready to go to court with you and say, let's give it a go and see whether he's infringing on our fundamental right to choose how to present ourselves to the world, absent him having a good reason. So the key is to think about the combination of there are no absolute rights, nor are there absolute powers. And so the key here is, can the government justify this policy decision? And the level of justification is higher when there's precedent on the books that says this gets the higher burden of scrutiny. And there's the potential that this very unique circumstance across the globe could create new case law where we will establish new. They won't be listed unless we amend the Constitution, but they could be doctrinally protected. So as a theoretical matter, again, just to kind of play the hypothetical law school hypothetical game, if Governor Gavin Newsom said you have to wear a mask and it had a particular message on the mask, and I have to walk around and communicate something to my fellow citizens, then again, I would think that would be subject to the strictest level of scrutiny, and he would have to demonstrate as the state, as the leader of the state that has a general police power from the federal Constitution to protect my health, safety, and welfare. There needs to be some demonstration that the regulation has that as a purpose, and it has to be a compelling government purpose, because the state can most definitely violate your federal rights, and I don't want us to be misunderstood to be suggesting that's not true. So while states have a general police power, the state can still violate the Equal Protection Clause and still violate the Due Process Clause and can still violate your substantive due process rights. So you indeed do have unenumerated fundamental rights that are probably innumerable and capable of being listed. But the key here as to why the state governments are on very solid doctrinal ground is they have what if we gave it to you on a con law exam would be kind of an easy, and it would be a give. It would be, well, why are they doing it? They're doing it for, it's not war, but it's darn close, right? We're at war with the virus. We're trying to keep Americans alive. So they have a very good purpose.
So let me ask a direct follow-up to that. We've gotten a couple questions about vaccination. And I gather that even if, this may be what you were just about alluding to, Professor West-Faulcon, even if we have a generalized right of bodily integrity against physical infringement by the state, that these may be special circumstances that would permit vaccination in circumstances that might not otherwise, where violation of that bodily integrity might not otherwise be permitted. Professor Caplan, is there history on this? What do we think about whether the Constitution permits vaccination or not? And should we get a vaccine here? Is that going to be something that the government's allowed not only to encourage us to do, but require us to do?
Yeah, so it's great that you asked about, is there a history? Because under our system where we're supposed to be bound by precedent to a large extent, you can say, oh, that got answered back in 1905. And in fact, there is a prominent case from 1905 that went to the U.S. Supreme Court called Jacobson. It was Jacobson versus Massachusetts, and they had a public health order that said everyone needs to be vaccinated for, I believe it was measles. In the Jacobson case. And so somebody said, hey, what about my freedom? I should be able to decide what goes into my body and what doesn't. And Mr. Jacobson may have also said, I think this thing is dangerous. Whatever, the Supreme Court, in an opinion by Justice Oliver Wendell Holmes, said, hey, we don't get to make all of our individual decisions about every kind of freedom that we want.
And let me. I'm sorry.
Yeah, no, please. That's as good a place to pass the baton as any.
I want to thank you, because the precedent is very much on point. But I also want to continue on the point of, we don't have a constitution of absolutes. And that's what means we live in a free country, because I'm always telling my con law students, don't leave all of the common sense and the things you know when you come inside the door. While it is absolutely true that the government has the power to require vaccinations if you are going to go to public school, collective good, we've collectively been taxed, and your people are required to go to public school, you don't get to opt out. It's still not absolutes. If you're here logging in from California, you probably know someone who doesn't want to vaccinate or has an objection to vaccination, and there are, to some extent, exceptions. If you have a valid, I should say, a sincere religious objection, in various states, you're permitted to opt out of vaccination. Even my public school example, right? In certain contexts, you're able to opt out of sending your child to public school, and you're not subject to truancy laws and regulations. So what would absolutely be a violation of our Constitution is some oppressive, tyrannical version of, we're coming to your house, and if you're saying no, we're pinning you down, and a government official is injecting something into your body, that absolutely is unconstitutional. And so there's a complexity to how you would lay out what gets us from the difference between that dystopian, movie scene and what none of us know exactly how it will play out. But I want to be very clear and be on record, since I assume we're going to record this, that I am not taking the position that neither the state nor the federal government has an unlimited power to inject things in your body, no matter how good the purpose is. So there's going to have to be some nuance in it. And so the way that you can create a lot of division, create a lot of misinformation, and we see it all the time on cable news with talking heads, is to present outrageous hypotheticals. Now, sadly, we live in a current world where sometimes I turn on the television, outrageous hypotheticals are actually happening in our lives. So it's good that we keep on our toes. But if we have reasonable government regulation with, again, top level, the highest purpose you could imagine, the highest, most compelling purpose, And then the key is, this is the piece of just con law lecturing I haven't been able to get in yet, so thanks for tolerating me. It's the means ends fit. We talk about a law gets over one of these hurdles because what the government says is its purpose, its end, is also narrowly tailored to what the law does. So the how you require vaccinations is also going to be the other prong of the test. So just because you have an exceedingly great purpose, which is keeping people alive, again, all of these extreme dystopian hypotheticals that are good to get on the news with your poster in front of the Capitol are things that most of us would agree with. No, I don't want the government to do that horrible thing either. But if it is to go to public school, if it is to go do X, Y, or Z, that you have to demonstrate that you're vaccinated, and there's some out if you're uncomfortable, then I think that is much more likely to be constitutional. But a very rigid, we're going to pin you down and physically strap you in is not something that I think the U.S. Constitution would tolerate.
Well, and one of the things that's a safeguard in that respect is the voting structure that the Constitution puts in place so that we can tell our elected officials what we're willing to tolerate and not. Most of the very reasonable tailoring that you described, the Constitution sets some outer bounds. It's absolutely true. But most of it happens ex ante at the state level, at the federal level, because our representatives, executive or legislative, are in theory responding to us about what we tolerate and what we wouldn't. Pitch forward to a conversation we're going to have in just a couple of weeks on COVID-19 and the voting process. But those are also some safeguards in the Constitution that keep things in the range of a relatively reasonable middle. I want to come back to something that you both have mentioned in different contexts and that also came up in the questions, and that is the role of religion in all this. So some of the controversy has been specifically about shutdown orders affecting religious services. And I want to know, what is the Constitution, what's the federal Constitution say about the extent to which shutdown orders can, in fact, stop people from gathering in person or can stop church services when both when other similar gatherings are not prohibited and when other similar gatherings are prohibited. Professor Caplan, I know you've done a fair amount of work in this zone.
Yeah, so now we're in the area of enumerated rights. You know, the First Amendment to the U.S. Constitution says that the government shall not prohibit the free exercise of religion. So one big battle that's been going on for decades is, does that mean that if I have a religious objection to any law, I should be able to claim a religious exemption to it? And the general answer to that is no, but it depends on what kind of law we are dealing with. So to take the easiest example, there's laws that say you don't get to murder people. And if you have a religious commitment that says, no, I want to engage in human sacrifice, well, too bad, nobody gets to engage in homicide. But what's happening with the current set of laws is a more nuanced question of, is the law actually neutral? If it says nobody is allowed to gather in a room with more than 10 other people, and it doesn't matter whether it's a movie theater, it doesn't matter whether it's a musical performance, dance, or class, or religious ceremony. If it just said no gatherings of 10 or more people, then we'd be in that situation that I talked about. Every activity is being treated the same, and the reason that you want to gather in a room of more than 10 people is a religious one. Well, so be it. Everybody has to obey certain laws. But what if the law said you can gather together in groups of 10, you can't have more than 10 people in a room unless they are going to a constitutional law class? Well, and let's throw in another one for country music performances. All right, so now we're making some exceptions. Is it still a law that applies to everything? If it's a law where the government is picking out certain things and saying, all right, you get a little more leeway to do what you want, there are cases that imply that religion should get that benefit as well. If we're going to say going to crowded common law classes is okay, well, then you need a really good reason if you're not going to say you can go to a crowded religious service. So there's been litigation about this, including here in California, where ultimately what is at stake are California's current orders, are they set up in a neutral fashion that applies to everybody, including churches, or are they being written in a way that gives some kinds of activities more leeway, and the churches should be able to have the same amount of leeway? So in the most prominent case, a trial court judge said, California's orders apply to everybody, including churches. There's no religious violation here. And the Ninth Circuit just this week upheld that on a 2-to-1 vote. Now, this is at a preliminary phase. This is at the preliminary injunction phase, so we'll see what plays out later. There was a dissent in that case. And so what the dissent was about was looking at the details of the orders and saying, well, wait a minute, I see a way in which religion is being treated differently than X. For the majority, they said, no, these laws look pretty much like they apply to everybody. The dissenter was saying, wait, I see somebody who's got a better deal than a church does. Ultimately, the rule makers could come up with generally applicable rules if they wanted to and make these questions go away. So a lot of it has to do with the details of how the rule is written.
There's one more thing. I know we're about running out of time.
Can I jump in on that? Justin, let me just jump in, though, on the religion thing, since it's such a hot topic.
Sure.
One thing I want to make sure that we alert folks of, in addition to what Professor Caplan just said, is one, Professor Caplan did use the term implied. So a lot of times we're being asked that question about the black letter doctrine. So I just want to make sure we're really clear on the black letter doctrine, because it's pretty intuitive. I'm told my co-panelists that I'm geeked out about something's going into space. So constitutional law is not rocket science. Big picture, if you are targeting religion facially, if the law on the words of the law say not that these things are essential, but if it actually said anybody who is attempting to exercise religion or this particular religion, you are prohibited from gathering, then there's no question we're at the highest level of the hurdle, right? Then you're going to likely, as the government, not be able to regulate in that way. But I just want to also reiterate that irrespective of the fact that it is an enumerated textual right in the First Amendment, there's not an absolute right to exercise your religion, nor are there absolutes about the separation between church and state. Current doctrinal law in the realm of religious freedom is relatively, I won't say relative, is very nuanced. So the doctrinal rules would certainly tolerate regulating when religious services can take place. So what I want to just peg, and I apologize, Justin, for not even taking your moderator, so I'm just taking panelist privilege, but we are in the midst of, I try to tell my students, we also need to distinguish between constitutional theory, constitutional doctrine, and political ideology. I'm now adding misinformation and disinformation and campaigns to change the way the world is. We have an Attorney General of the United States, William Barr, combined with the President of the United States, or not even for the president, it's not a genuine ideological commitment to religion, but it is for a political purpose. We have an agenda to use religion as a wedge issue and to tell people that their rights are being infringed and encourage them to bring litigation, even with the knowledge that much of this regulation is to save lives. So it is an effort to raise up particular religions, not all religions, because we also have an administration that is not willing to protect minority religions. So it's a very perverse future we might have with respect to constitutional law, where we teach our students that there's an obligation for the courts to step in and protect numerical minority religions, and discrete and insular minorities. But something that I've articulated in a class that actually had this as one of the focuses this semester is that what I expect we might see from this current Supreme Court is a greater protection for a group that is a religious majority, Christians. And I am a Christian. I'm a Christian from the Bible Belt of North Carolina, where you have a governor who has said, you can worship, You just have to worship outside. So what you're not seeing in the news and cable news is the fact that that is pretty darn narrowly tailored. It's saying the church can get together, but to save some lives, don't go inside. Pull out some chairs and some folding chairs and go out and pray and sing outside in front of the church. That is absolutely reasonable regulation. So apologies, but this is really important, because I don't want to suggest or imply that that there's not protection for religious freedom, but this is about narrowly tailored regulation.
And I'll say that one of the things, I know we're creeping right up on time, so I'll mention two things really quickly. One of the lines of doctrine that both Professor West-Faulcon and Professor Caplan have articulated have to do with past precedent, case in the 80s and 90s, about the role of religion and the roles of neutral laws of general applicability, right? If a general law applies across the board, is there a religious exemption? That was hugely contested in the 90s when it came out. There was a federal statute that came right afterward attempting to recalibrate the deference given to religious preferences and religious conduct, both sincere and, as Professor West-Faulcon implied, opportunistic. That fight is not over in the 90s, is not over today. There are some cases, as have been mentioned in the chats, that are trying to push reevaluation of that doctrine up through the lower courts and into the Supreme Court to find out if there will be special exemptions for religion given its textual enumerated status in the First Amendment. And exactly what that looks like, even if the court decides to reevaluate, will inevitably depend on the particular context. As Professor West-Faulcon saying, you're not going to have unilateral maximal exemption for any professed religious practice, no matter what happens in the courts. The Constitution just doesn't work that way. The last thing I want to leave with, because we've been spending this entire time on rules generally imposed by the states. And Professor West-Faulcon mentioned misinformation. There's a lot of misinformation about what the federal government can do to reopen the country or to open up particular states. And the short version, just for anybody watching who's been confused about the extent to which that's been a trope in the media, is that until Congress gives the president the authority to pursue the regulation of commerce on Congress's behalf, the president has no authority to unilaterally or otherwise open or reopen parts or all of the country. The president has the bully pulpit to make recommendations, and he will certainly continue to do that and urge various state officials to relax their various states of emergency. But absent Congress passing a specific law giving the president the authority to drive people back into business, the federal government at present has no particular authority to do that whatsoever. I felt the need to mention, just because it's such a trope about the president reopening the country, either in part or in toto in the news. And as those of you who've already taken all of our con law classes know, that's not a thing, at least not until Congress permits that power. We're 2 minutes over the time that we promised to let you go. These are meant to be informal lunch bites, little conversations for 45 minutes. I don't want to take up any more time than that. I really thank you for joining us in this series. If this has been of interest, there's plenty more there, including contacting us. But we'll have regular lunchtime conversations on different legal topics, some public law, some private law, some about artificial intelligence tools that have to do with legal regulation and the outer expanses. We really appreciate your time today. We hope that you've enjoyed. Please join me in thanking Professor Caplan and Professor West-Faulcon for this little session. We hope it's whet your appetite for more. We really enjoyed talking to you.
Thanks for attending.
Thanks for having us.
Thanks, everyone. Be safe. We hope to see you back in this forum or others very shortly.